Hello and welcome to Competology Academy. And today we are going to discuss our next part of Santhal Pargana Tenancy Act of 1949. And those who have not subscribed our channel and are willing to prepare for the JPSC and other government exams that are conducted by Jharkhand government, then they can go on to subscribe our channel and press the bell icon to get notified whenever we upload such new videos, right? So here today we are going to discuss about chapter 3 section 21 to 24, and we are analyzing the whole Santhal Pargana Tenancy Act, that is section by section and chapter by chapter. And today we will be concerned about chapter 3, that is second part, because the chapter 3 is the largest chapter in the Santhal Pargana Tenancy Act. And here the descriptions are about the Rayyat, their authorities and their responsibilities, their like rights on the land and the other things, right? So here section 21, it says that the transfer of Raiti land by Bhugat Bandh or complete UC factory mortgage by a non-aboriginal Rayyat and its limits. So we have already discussed about the Bhugat Bandha mortgage or the complete UC factory mortgage. So what is it and how it is done and what are the terms and conditions of this mortgage system? We have already discussed about that. So now here it says that notwithstanding anything contained in section 20, because section 20 was concerned about the mortgage and the other transfer rights of the aboriginal tribal people of Santhal Pargana region, how they can transfer their holding, how they can transfer their holding through sale, deed, mortgage, or whatever it is, right? So here it says that the state government may by notification on this behalf published in the official gazette permit the non-aboriginal Rayyat either of whole of the Santhal Pargana or such portion of it as may be considered desirable to transfer with effect from such date as may be notified their rights in their holding up to the extent of 1/4 of their paddy first class Bari lands by Bhugat Bandha or complete UC factory mortgage. So first thing is that the non-aboriginal Rayyats of the Santhal Pargana region can transfer their land through the method of Bhugat Bandha mortgage or the complete UC factory mortgage. However, there is a limitation that they cannot transfer more than 1/4 of their first class Bari land on which the cultivation of paddy, that is rice cultivation, goes on, right? So this will be the condition. The second condition is that only it will be effective of it is notified in the official gazette of the state government. And third point is that the date from which it will come into effect, that will also be notified by the state government. So it does not come into effect as and when the act itself comes into effect, but that authority to make it effective through the complete UC factory or Bhugat Bandha mortgage will be with the state government. They can notify it through the official gazette notification, right? And here it says that the land mortgage can be done to bank duly established by the state government or a grain gola approved by the deputy commissioner. So those banks which are owned and which have been established by the state government, to them the mortgage can be done, or to the grain gola like that of where the grains are sold, right? So grain golas are the establishments where the grains are sold because they hold too much of the money and they also go on to do the cultivation work. So for that matter, if some of the aboriginal agriculturist or the farmer wants to get some money for some kind of purpose, then they can give their land to them, that grain gola establishments, through the complete UC factory mortgage. But that grain gola should be registered or deemed to be registered under the Bihar and Odisha Cooperative Societies Act of 1935. So that grain gola should be recognized one, that should have been registered with the government under the Act of Bihar and Odisha Cooperative Societies Act of 1935, or a Rayyat of the Santhal Pargana region. So lastly, a Rayyat of a Santhal Pargana region can also take the land of another Rayyat, non-aboriginal Rayyat, under the complete UC factory mortgage system, right? So this is the first subsection, and the another part of subsection is that no such transfer shall be recognized as valid unless it has been made by the means of registered deed. So registered deed, the agreement paper, the other things, the documents should be prepared for such kind of complete UC factory mortgage. Then only it will be legal, then only it will be recognized by the government, and it should be reported in the prescribed manner by the transferor and the transferees to the DC. So after registering the deed, after completing the whole process of the mortgage, that information should be passed on to the deputy commissioner of the district that this land has been kept as the complete UC factory mortgage or a Bhagat Bandha mortgage. Both are the same thing, but the only thing is that one is in the local language, that is of the tribal language, and one other one is in the that of English language, right? And to the landlord, after the DC, they have to inform the landlord also within 1 month of the registration of the deed, because after keeping the land as a Bhagat Bandha mortgage, the responsibility to pay the rent on that land goes on to the that of new owner or the person who has taken that land as a Bhagat Bandha mortgage, and it does not remain with the original Rayyat, and that is why the landlord should also be informed about such kind of things, right? And no such transfer shall be made for a period exceeding 6 years. So the limitation of the Bhagat Bandha mortgage period will be 6 years, right? And after the expiry of 6 years, the land will be reinstated back to the original owner, right? It will be transferred back to the original owner, that is the transferor Rayyats, right? And it is permissible for a period of 6 years only. Here it is clearly mentioned, and here some of the terms and conditions are also there for such kind of Bhagat Bandha mortgage. And one of the important one is that the costs are required to be processed for the transfer and redelivery of the possession after 6 years shall have to be deposited with the DC. So when the land will be reinstated back after the expiry of the Bhagat Bandha mortgage to the original owner of the land, that is the transferor of the land, will be deposited in advance to the deputy commissioner of the district, so that there will be no issue with regard to the reinstating back of the land to the original owner of the land, original Rayyat of the land, after the expiry of the Bhagat Bandha mortgage, and the transfer shall not be valid without the same if the money is not deposited in advance for reinstating back the land. Like there will be registration fee, there will be other things that will be there. So for that matter, all these costs that will be incurred after the expiry of the period of the Bhagat Bandha mortgage to reinstate back the land to the original owner will be deposited with the DC in advance, then only it will be valid. The transferee shall pay the rent of the land at the settlement rate for the area and shall be evicted immediately with the cancellation of the mortgage on his failure to do so. So this is the reason why the landlord should also be informed about such kind of mortgage, because after this mortgage, what will happen? The land rent will be paid by the person who has taken the land as mortgage, and if he is unable to pay the rent of that land, then the mortgage will be cancelled with immediate effect, and that land will be reinstated back to the original owner of the land, right? And here, on the expiry of the period of the mortgage, the DC shall on his own motion cause a notice to be served to the parties to transaction that the period of the mortgage has terminated, and shall proceed to evict the transferee and deliver the possession to the transferor Rayyat. So on the expiry of the period of the mortgage, the land will be immediately transferred back to the transferor, that is the original owner of the land, and for that matter the DC will serve the notice to both the transferee and the transferor, and thereafter he will serve the notice and he will start the process of redelivery of the land back to the original owner of the land, right? Now here the next point is, any transfer of the land made otherwise than under the provisions of the foregoing subsections shall be deemed to be transfer made in contravention of subsection 1 of section 20. That is, it will be termed as illegal transfer, and in such case the transferee will be evicted with immediate effect and the transferor will get back the land with immediate effect if all the foregoing subsections and its terms and conditions are not fulfilled, right? Now, any mortgage found in possession of any land belonging to a Rayyat after the expiry of the period of such mortgage period shall be punishable with imprisonment. So, if any Rayyat is in possession of the land even after the expiry of the mortgage period, then he will be punishable with the imprisonment. The punishment will be in the form of imprisonment, right? So this is again a condition. Now here a short information about our books that are published, that have been published in fact, and these books are available to be ordered on our website also. These are available on the Amazon also. So here these are the books for UPSC civil services in English medium, and these are the books for UPSC civil services in Hindi medium, as well as in both the mediums the JPSC books are available. So if you want to purchase these books, you can go on to order it from our website, our app, or you can contact us directly from the contact details that are provided in the description box below, and these are available on Amazon also. Now come to section 22. So a Rayyat may make over his holding temporarily on the trust for cultivation. So a Rayyat can give his holding on trust to somebody or to any trust establishment, to a trustee for cultivation for temporary period, and there are certain conditions that should be fulfilled before entrusting any trust for cultivation of the land, right? So notwithstanding anything contained in section 20 and 21, in the event of Rayyat's temporary absence from the village, or his sickness or physical incapability or loss of plug and cattle due to any cause beyond his control, or Rayyat being a widow or the minor. So all these conditions make a Rayyat incapable of cultivating his own land, and in such cases what will happen? His land will remain as a fallow land. So in such case his livelihood will be jeopardized, as well as the government will not get the rent, not get the remuneration or the revenue from that land. So for that matter, the government has allowed such kind of Rayyats who are incapable of cultivating their own land for all these following circumstances, to give their land in trust to cultivate their land to some of the Rayyat or some of the societies, right? So he may, after informing by prescribed post the village headman, Mul Rayyat, landlord as the case may be, and the subdivisional officer, that is the SDO. So these officials should be informed in advance before keeping his land in trust to somebody, and hand over his holding temporarily on trust for cultivation to a Rayyat of the Santhal Pargana. So that establishment or that Rayyat should be within the Santhal Pargana region. Then only he can give that land in trust for cultivation to that person or that establishment. And in cases covered by subsection 1, if no period has been stipulated and the Rayyat does not resume the cultivation himself, the holding shall be presumed to be abandoned after the expiry of a period of 10 years. So in trust, a Rayyat can give his land for a maximum period of 10 years, and if there is any specified time period, for that time period it will remain with the trustee. And if in case there is no specific time mentioned during the transfer of the land in trust, then in such cases what will happen, the maximum period for which the transfer of the land in terms of trust is allowed for a period of 10 years only. After the expiry of 10 years, the DC will consider such holding as the abandoned holding or left out holding, and in such case any transfer of a holding for cultivation, temporary or otherwise, made otherwise than under the provisions of subsection 1 shall be deemed to be a transfer made in contravention of subsection 1 of section 20. So here everywhere you will find the mention of subsection 1 of section 20, and this is because subsection 1 of section 20 stipulates or mentions the type or the manner in which any of the transfer of the land under the SPT Act in the Santhal Pargana region can be pronounced as illegal and invalid, and that is why subsection 20 subsection 1 of section 20 becomes very important, and time and again you will find this question in paper, right? Now section 23 says that if somebody wants to exchange his land for convenience, so in such cases what are the terms and conditions that should be followed before the exchange of land? So first of all, exchange of righty land can be done, and the rayats desiring to exchange their land may apply in writing to the DC. So without the permission of DC, without the permission of the deputy commissioner, no land can be exchanged, right? And here the DC shall not permit an exchange to be made unless he is satisfied that the parties to the exchange are rayat with respect to their respective lands proposed to be exchanged. So it is, should not be there that you can go on to exchange the land of other people. So first of all, the DC will verify that these two parties of the exchange are rightful owner of their land which they are stipulating to exchange. Otherwise the DC will not permit the exchange of the land. How can you exchange the land of some other people and you will get a fresh piece of land, right? So this will be there. And next is that the lands proposed to be exchanged are situated in the same village or in the contiguous villages, and the transaction is not a concealed sale. So these things should also be verified and adjudicated by the DC, that the lands are situated in the same village, as well as it can be situated in the contiguous village. Means that if this is a village in which the one piece of land is situated, then the other land should be situated in the same village or in contiguous village, means that those villages which are located around this village, adjoining villages, right? Then only these lands can be exchanged, right? And this should not be a concealed sale, which means that the bona fide transaction should be for the convenience and not for a commercial purpose, like some person will give a person a land in the remote areas where there is no road or something like that, and he will in exchange get the land located at a highway so that he can go on to do some commercial business or something like that. So these type of exchange will be considered as a concealed sale, right? Now here it should be bona fide exchange out to be made for the mutual convenience of the parties, and the lands proposed to be exchanged are of same value. So this will also be analyzed that the exchange is being done with two lands, between two lands that are of same value. There should be no differences in the value of the land, as well as there should be no transaction of cash, or that the money transaction should not be involved in the exchange. And in cases covered by subsection 1, if no period has been mentioned stipulated by right, so this is not related to this section, so leave it. And any exchange of the land made otherwise than under the provisions of subsection 1 or without a written permission in writing of the deputy commissioner shall be deemed to be transaction or the transfer made in contravention of subsection 1 of section 20. So if the terms and conditions those are mentioned in subsection 1 of section 23 are not being followed, as well as if the DC finds that this is a concealed sale, then in such cases the transaction, the transfer or the exchange will be considered as violation of subsection 1 of section 20, and it will be pronounced as illegal transaction or illegal exchange. Now come to section 24, that is registration of certain transfers of the Raiti holding. So if any of the transfer of the land is done, then those lands, those transactions, those transfer of the land should be registered with the landlord, so that the landlord should be informed that now onwards who is going to pay the malguzari or the rent of the land, and to whom I have to contact for such kind of things, right? So in sale, gift, will or exchange of the Raiti holding in accordance with the provisions of this act, and the record of rights shall be registered in the office of the landlord. For the same purpose as I have mentioned, the landlord shall allow the registration of such transfers and shall be entitled to levy a registration fee. So in case of any of the transfer of the land or transaction of the land, the landlord is allowed to charge the transfer fee or the registration fee or the transaction fee. Stamp duties and other things are levied even nowadays, right? And in the case of the transfer by sale, gift, will, notwithstanding anything contained in the record of rights or any statute or anything having the force of law in Santhal Parganas, on all of these transactions, the transaction fee, the registration fee will be charged, right? Now, no registration fee is necessary to be paid to the landlord if the gift is made to the donor's husband or wife. So if somebody is giving his land, transferring his land to his wife or his husband, then in such cases no transfer fee or the registration fee will be charged. In case of transfer to the son adopted under the Hindu law, or to the donor's daughter, sister, adopted son or adopted daughter under the Santhal law, or to the relatives via co-sanguinity. Co-sanguinity means what? If the person, the successors, that like the son of a father is getting the land transferred on his name, then it is considered as co-sanguinity, that is the rightful owner, rightful successor of that particular piece of land. So in such cases there will be no charge of registration fee, right? Now if any land lord refuses to allow the registration of any such transfer as is mentioned in the transferee or his successor in the title may file a complaint to the DC, and there is no right with the landlord that he will not allow the registration of the transfer of the land, right? So if you go on to apply for the mutation of that land right or record of rights, and you want that your name should be updated in the record of rights, that is the khatian nowadays, what is known as, then in such cases if the CO denies that we are not going to update this without any law in force at that very time or without any government order, in such case you can go to complain, file a complaint to the DC. This is your right, right? Now here the next section is section 24A. This was introduced through amendment, and here it says that registration of certain transfers of homestead land, that is gharbari. In Hindi it is known as gharbari, right? So here the transferee or his successor in interest may cause the transfer to be registered in the office of the village's landlord when a homestead or any portion thereof which a Rayyat holds otherwise than as part of his holding as a Rayyat is transferred by sale, gift, will, exchange in accordance with the customs or the record of rights. So this was a situation where many of the gharbaris were sold along with the house itself, the buildings, the physical construction itself. And in such cases, the registration was being issue with the landlord. So in such cases, this was introduced through the amendment that these things these transactions or the transfer of the land in which the homestead land, that is gharbari, is involved, that will also be registered with the landlord and the record of rights will be updated, right? So these are the things. Now, notwithstanding anything to the contrary contained in the record of rights or in any law or anything having the force of law in the Santhal Pargana, the landlord shall allow the registration of such transfer and shall not be entitled except in case of transfer by sale or etc. to levy any registration. So in condition the landlord can charge, the registration is mentioned over here. It says that notwithstanding anything contrary to the record of rights. So whatever is mentioned in the record of rights, it doesn't matter, or any law in force in the Santhal Parganas, the landlord shall have to allow the registration of the transfer that is made through sale, gift, will, or any of the allowed form or allowed method under this act. So the landlord is liable to register that transaction, right? And if any, or if the landlord is doing some frivolous things, then the person who is the party to that thing, then he can go quite easily to the DC and file a complaint that he is refusing to do so such kind of things, right? And section 25 and 26 contains the detail regarding the process of transfer of the holding of Raiyat by sale, gift. So whole procedure is delineated under section 25 and 26. And here we finish off chapter 3 of the Santhal Pargana Tenancy Act. If you watch the video till the end, then please go on to subscribe the channel and press the bell icon to get notified whenever we upload new videos, whenever we are applied, whenever we are live, right? And you can also download our app. The link is provided in the description box below. The app is available on the Google Play Store. There you will find various study materials, lectures, and the free resources for your studies. The same thing are available on our website also. You can also follow us on our Facebook and Instagram handles. And here we finish off. Thank you very much, and get back and join us on the next video. In the next video, we'll go on to discuss chapter 4 and chapter 5 of the Santhal Pargana Tenancy Act. Thank you very much and have a nice day.